I'm Joanne Henderson. I'm a partner in the employment team at Meyerson, and I'm joined this morning by my colleagues Patrick Byrne and Jack Latham, who will also be speaking. They're both associates in our team. In terms of our agenda, the good news is, I suppose, that there isn't one big piece of legislative change that's happened over recent months, or that is planned particularly. The government seems to have other things on its mind. We have, however, seen over the last 6 to 12 months changes in trends and changes in working practices that bring legal implications. There have been a few important cases and some small pieces of legislative change around reform. So our intention this morning is we've picked our top 10 things that we think that you should be aware of, and we'll work our way through those observations. I'm going to kick us off talking about collective employment law issues around trade unions and collective issues. I'm then going to hand over to Patrick, who's going to talk about home working and the legal implications of that. Jack's going to pick up all issues relating to pay, and then I'll just finish off and talk about the mystery of whatever happened to the employment bill for a few minutes as well. So I'll make a start so that we do keep on time. So I'm first going to talk about industrial action, and if you have watched the news at all over the last year or so, you will have seen a great change actually in union activity, in particular around industrial action and unions calling for strike action. And we've seen it right across the public and the private sector, so we've seen it a lot within our department, and you will have noticed it in particular around the transport industry, education, communications, and of course this week we are all very concerned about potential industrial action within the NHS. And so it is a growing trend that we're seeing. The government have used words such as the trade unions being militant, and commentators have said that perhaps we're going back to the 1970s. I don't think we are going back to the 1970s. We do have growing activity. Union membership is also growing. I think membership within the workforce is between 20 and 25%, compared to about 40% in the 70s. But the number of disputes has probably quadrupled or so over the last couple of years, largely arising out of the cost of living crisis and disputes around pay. So what has the government's reaction to that been? They changed the law in July this year and made 2 changes to industrial action law in response really to the strike action proposed by transport workers and the potential disruption that would cause. The government's justification for changes that was going to affect the economy significantly. And so they introduced 2 changes. The first of those was to reverse the prohibition on using agency workers to backfill the positions of those staff who were on strike. So before July, it was unlawful for an employment business, an employment agency, to supply an agency worker to backfill that position. Employers were needing to cover those roles by using their current workforce, and obviously that was quite a difficult thing to do. So this reversal is quite significant because it very much undermines the effectiveness and the impact of the strike. So it's quite an important change, albeit sounding quite a small change. Unison and the TUC have both made judicial review applications separately on the grounds that that law cannot be a permissible law because it cuts across the right to associate, and the right of association and the right to strike. So that judicial review application has not yet been heard. So the current position remains that if you're facing a strike, you can use agency workers, subject of course to them being properly qualified, particularly in the context of the NHS or the transport industry, to comply with all of the other statutory obligations that employer might have. So that was the first change that they introduced. At the same time, the government made a change to the union's position, their protection from liability. So where industrial action is called, particularly strike action, the effect of that is the union is inducing a breach of contract on the part of the employees, or it might be causing interference in the employer's business, and both of those are industrial torts, and normally a claim for damages could be made as a consequence of any damage caused by those actionable torts. Trade unions are afforded under the Trade Union and Labour Relations Consolidation Act immunity from liability for causing those breaches. Immunity can be lost and damages payable by the unions where, for example, the strike action is unlawful. And that might be because it involves a secondary action, so the union getting involved in a dispute that it doesn't have an interest in, or it might be because the union has failed to comply with the strict obligations around balloting and providing notices to employers about strike action. So if the immunity is lost, the union can be sued in damages. The more typical response from an employer is to try and get an injunction to stop the strike action at all, but alternatively damages may be claimed. And again, the change that the government has made here is to raise the cap on damages that can be claimed from the union. The damages are scaled depending on the size of the membership within the union, but even the largest unions had a damages cap of £250,000 prior to July. That's been quadrupled up to £1 million. Again, that's intended as a deterrent to ensure that unions think very carefully before calling a strike and that they comply with all of the relevant legislation. Sticking with collective issues and how unions might flex their muscles a bit, if you were with us in our update earlier in the year, you remember that we talked about the case of Coastal and the special rule in the legislation which says that where a union is recognised by an employer for the purposes of collective bargaining, it's unlawful for the employer to try and bypass that collective bargaining machinery and go direct to employees with offers to change their terms and conditions of employment or pay. An employer is only enabled to do that in very special circumstances where the collective bargaining processes have been completely exhausted. So in the Coastal case, which was about a year ago now, in that case, there was a very obvious breach by the employer. They had a written process, a procedure for collective bargaining and a procedure for resolving disputes. They didn't complete it. There was a dispute around pay and they made an offer direct to employees, and the effect was that they had breached that special rule and protection of collective bargaining rights within the legislation. Since then, we've seen another case on the same theme, and although the law's been there for very many years, we hadn't previously seen this litigated until recent years. This is the Ineos case, the chemicals giant. They were in pay negotiations with their union, and their situation was quite different because they didn't have a specific collective bargaining process or procedure written down or established. And they just had annual pay negotiations. Ineos talked to its unions over a period of 5 months. There were 5 meetings, and Ineos got to the point where it made a final pay offer to the union. The union refused to take it to ballot. They didn't ballot it, but they tried to continue the negotiation. And Ineos took the view that the negotiations had broken down, and they wrote to all of their employees and enforced their pay increase. They implemented the pay increase that was their final offer. Again, that case has worked its way through the courts, and the courts have found that that also was a breach. And the reason for that was that at the point when Ineos decided to implement their pay offer, the negotiations between the two parties were not terribly far apart. They were about 1.5% away from reaching agreement. And what the court said was that it was, as an objective bystander, it was not possible to say that it was not possible for the two parties to have reached agreement at some point in the near future, and therefore they hadn't exhausted their collective bargaining process, and that it was an unlawful offer that had been made to the employees. The penalty for doing this is really significant. So for each person that has received that offer and who is a union member, there's a penalty of over £4,500. So if you're looking at a workforce even of only 100 people, you're looking at a bill of up to about £500,000 for having got that wrong and made the offer to employees at the wrong point in time. In addition to that, any changes that you've introduced to the contract of employment would not be valid. So it's a very big mistake to make. And I think the lesson there is that if you are going to have a relationship with your unions where you are collectively bargaining and negotiating around pay, firstly, that process has to be really clear, and it has to be clear when it will become exhausted. So they have a proper documented process so that that's known to all of the parties. And secondly, you've got to be able to evidence that you are not going to be able to agree any changes to pay or otherwise through the collective bargaining process. You've got to be able to demonstrate that you're at an impasse, and that's quite a difficult place to get to. But the penalty of getting it wrong is very significant. Sticking with collective issues, not necessarily union related, but often union related, I just wanted to mention the fire and rehire tactics. That's been a hot topic over the last year, and in fact we did cover it at our last update, but I just wanted to cover it again because there has been a bit of a development here. So you'll remember that this became a very unpopular tactic to use in the context of the pandemic. It was very much criticised, and ACAS issued some advice around the importance of consultation and the importance of having good business reasons when you are looking at an exercise where you have to get to the point of terminating contracts and re-engaging to effect a change in terms and conditions. So in March last year we had the P&O debacle, and the government, having previously said they weren't going to do anything about the practice, said that they would issue a code of practice. That was due in the summer and we didn't get it. In a parliamentary debate just on the 3rd of November, so within the last week or so, there has been a comment from the Minister to say that the code of practice is due in the near future, so it does seem to be more imminent. Some information was given about what the code might include. The government will not ban the practice of terminating contracts and re-engaging to achieve change, but quite worryingly, the Minister said that fire and rehire should only be used very much as a last resort. For example, where the business is in a critical state, or where the alternative would be closing the company and everybody losing their jobs. And so that's a really high bar before you can consider terminating contracts and re-engaging. And that's not a proper reflection of the current legal position, because the case law is that you have to have a sound, good business reason, that it has to be a reasonable decision, and that you've taken all reasonable steps to consult and all of those things before you get to this point. So it is a last resort, but it is a permissible practice. The ACAS code, for example, says that the business, if it's considering this option, can have a business reason that is an economic reason and necessary to maintain a market position. So that's a much softer test than the test of there being a critical situation where people might otherwise lose their jobs. It might be that that was quite loose language used by the Minister, and we'll have to wait and see the code, but it's certainly something for us all to keep our eyes on. And I suppose if you are looking at one of these exercises, sooner rather than later might be the way to go. The sanction for getting it wrong, and so not following the code of practice once it's in force, is that if there are tribunal claims associated with terminations on that basis, that the compensation might be uplifted by up to 25%. So again, quite an important sanction to bear in mind. That's all I've got to say on collective type issues. I'm going to hand over to Patrick, who's going to talk about homeworking.
Thanks, Jo. Hi everyone, I'm Patrick, and I'm going to start by talking to you about home working and hybrid working. So obviously, this is a way of working that became obviously mandatory almost overnight for most companies during the pandemic. And we've seen a sharp rise in its use. So a lot of us are familiar with working in our living room, working in our kitchen. But since we've moved out of the pandemic, it's actually lingered as an expectation of existing employees. And it's certainly something that hires are actively looking for from their next employer. So I think whether you've already got one in place and you want to make sure it's fine-tuned, or whether you're still looking to introduce one, hopefully, I can show you some of the key components that you need to build in and factor. So just a few benefits to start with. I won't say too much because I think they're quite self-evident that if people are working from home, you're perhaps going to benefit from a reduced requirement on office space. Maybe that results in a downsize, or maybe you just notice associated costs in the office reduce as a result. There's the mental benefits of people perhaps being able to juggle their lives a little bit easier. So that can lead to productivity, that can lead to a more motivated employee, and retaining staff and being able to go out and perhaps recruit from a wider geographical pool. These are all things you can benefit from. And then the last three, I suppose, are perhaps about future-proofing your business a bit. People learn new technologies, people are more flexible. You can get your teams together at the click of a button. So if there are future lockdowns, let's hope not, if there are transport issues, you've perhaps got a more robust business as a result. Some drawbacks, obviously these are just potential, so not everyone will experience these, but perhaps you end up with something of a two-tier workforce where maybe those that tend to work in the office are perhaps getting a little bit more exposure to managers, they're benefiting a little bit more from that supervision. Maybe when it comes around to appraisals, they're more noticeable as a result. Culture, collaboration, management oversight, these all kind of boil down to communication and interaction. And obviously, if you've got that home-based workforce, maybe these things are being hampered as a result. Productivity, again, the same point really. There's a bit of a perception from some perhaps that if someone's at home, they're not going to be working hard enough. Some people hold that view. There is research to show that perhaps doesn't carry weight in practice. People often end up doing a bit more work when they're at home. And then mental health and well-being and data security there as well. So I'll take you through, I've kind of grouped them into 3 or 4 sort of umbrella areas that are, I guess, would be the foundation, the key things that you're going to have to think about when you put your policy into action. So starting with the goal, I think you'll need to be really clear on what it is you're actually trying to achieve before you get into any of the details. Because you've got a broad spectrum of systems here. Going from the traditional, we are exclusively office-based Monday to Friday, all the way through to maybe we're not going to have an office, we are purely home-based remote workers. And then all the shades in between of perhaps the employees can build the week themselves, perhaps they need management approval, perhaps there's a limit of up to 2 days at home, 3 days at home, many different options, but that should be a starting point to know what you're setting out to achieve. And then you need to flesh it out with the policy. So I've put 4 points there that are probably going to be the skeleton of most policies. Thinking about who's eligible, perhaps everyone's eligible and it's open to all. Perhaps there are certain functions you need to retain within the office. Approval systems. So you may have a relatively formal system where a request for home working, hybrid working is required, and it'll be considered on a case-by-case basis. Or maybe you want managers to have the discretion to say, so-and-so is underperforming, and I have the power to keep them in the office beside me. Or you've got a new hire and they need to be bedded in. Considerations like that. Duties of remote workers and their managers should all be laid out in the policy, along with other policies that employees need to comply with. So, managers need to know what they need to do as part of this system, and they also need to be running their teams productively. Employees, on the other hand, need to know that whilst they might be sat at home in their kitchen, they're still technically in the workplace, and they need to know what obligations and policies come with that. Formal contractual change, how are you going to actually implement this? And you could take the formal approach of saying, well, we are changing your contract of employment with this, we need your consent and we need you to sign. But you could feel that's a bit cumbersome and you might open yourself up to lots of questions refusals to give consent if you go that route. It may feel tidier or smoother perhaps to introduce it as a non-contractual policy, which you then implement. You obviously take feedback and questions, but you're not then going that more formal contractual change route. However, it's worth noting that if you do introduce it that way, certainly however you label it, the longer this stays in place, there's a good chance here that people will accrue that contractual right over time. So if you ever then build in, as I put here, a right to amend, a right to revert, depending on when and how you do that, you'll want to approach it carefully, because you could be changing someone's contract. Communication and equipment is obviously going to be crucial. Making sure people have the right tools. I think we've all learned that Teams, Zoom, Slack, these are things that are easy to use and they've become second nature for most of us. You do still get that person who's on mute in a call, but that's just going to be there forever. But otherwise, they're quite simple. And there's still a bit of a knack to running these things, especially I think if you're going to have hybrid meetings. Some sort of techno-jargon term that I stumbled across is presence disparity, which is basically where if all of you are in the office having a meeting together and two people are tuning in from home, the two from home basically get ignored, not deliberately, but it's just how our brains work. So thinking about little details like how could we rearrange the meeting room or have a bigger TV screen, little things like that, could draw benefits for you. And then rules on face-to-face time. I suppose from a social perspective, keeping that team unit together, making sure people are happy at work rather than off in little silos, getting quite lonely, perhaps their mental health is suffering, perhaps they're overworked. And also from a productivity perspective, there could be projects where actually we all need to be in and we need to be here together working on it. Or there could be certain functions like learning and development where it's worth having these face-to-face rules. So you want to make sure that your policy isn't too rigid that it prevents you from doing that. Training managers and successful supervision. So the manager knowing what their role is within the policy, it could be that they've got quite an important role, especially if your policy is going to be slightly more controlled for the business, slightly more rigid. It may be that the manager is a point where requests go to for flexible and home working. But obviously, whatever your policy is, they're going to have to know how to coordinate people's work schedules. They're going to have to do what they were doing in the office around performance management, but do it effectively when they can't actually see their team. And there's a knack to that, I think. So offering training on how to, for example, spot signs of underperformance, how to spot signs of certainly stress and other health conditions could be really important. I know anecdotally from our perspective, that has become a bit of a theme of performance processes, of capability processes, where HR and managers perhaps aren't spotting those red flags as soon as they were previously, just because they don't have that visibility anymore. So team cohesion, really important. And I've put in there again, relationship building and well-being and health concerns, really crucial. I think stress is such a recurring factor these days, and there seems to be some sort of correlation between home working and that. So if you've got a really observant manager who can liaise with HR proactively when there might be a problematic employee, that's really going to help you when it comes time to helping them get better, manage their health, or if it comes down to acting promptly and putting in a formal performance process and not letting that drag on. And then I've got compliance and other policies here. So obviously, home working, hybrid working, it's really doing your job in a different space. You're going to interact with all manner of obligations from the employer's perspective, legal obligations. You've got common law duties around health and safety to your workforce. You've got statutory obligations to make sure there's a safe system of work in place for them. And you're going to have to think of ways that you're actually going to comply with that. So easy to do when you're in your safe, secure office and you know that you've got great stations set up, the right equipment and all of the rest. But once you send people off and they're working wherever, you still need to be mindful that those obligations still exist. So thinking about things like risk assessments, if it's not possible to carry out a full risk assessment, perhaps self-assessments on people's working stations and setups, things like getting the height of the screens right so their back's not being put out, making sure they've got great equipment from you, your obligations on equipment. I mean, you're not obliged to kind of set people out with a home office, technically under law, but it can obviously be really helpful. That could mean laptop and keyboard. You might go a step further and thinking about your health and safety obligation, think, well, if we give them the chance to come to us for a great office chair, perhaps that's going to be a really helpful thing for them. Insurance policies. So, yeah, obviously all employers are going to have insurance policies covering employee liability, covering the office, equipment that's in the office, double checking the small print of those policies. Perhaps they cover home working, perhaps they don't. Do they cover all the new equipment that you've bought that's in people's homes? Maybe, maybe not. It's just worth covering these things off and seeing how far your liability is covered there. And obviously, if there are gaps, if home working isn't covered, it'll be about how do you get around that in terms of finding a new policy, or perhaps do you put some level of responsibility on the remote worker to cover insurance. And then finally, security systems and data protection. So again, there's a comfort to your office space. Theoretically, it should be secure. Your systems should be secure. If someone's on their laptop, either working at home, perhaps your policy lets them work in third-party remote spaces. How are you going to make sure that you're complying with your GDPR obligations to keep that data secure? And from a commercial perspective, I suppose that confidentiality is going to be preserved around your business information. So thinking about the tools that you can deploy there in a sort of electronic sense, it could be remote servers, more robust antivirus and firewalls, IT policies, making sure you've got those in place so that staff know they're not letting their guard down in a more casual work setting, and they know what they should be using your work equipment for, what they shouldn't be using it for. Also thinking about traffic between your office and the remote places of work is worthwhile as well. You may find since the pandemic you've gone more paperless, but you could still have employees needing to pick something up from the office, got it in their car, or they've got their laptop and they're leaving it somewhere. So just thinking about these different things and putting simple policies or training in place is going to protect you and help you comply with your obligations there. And then I've just done a bit of a summary page here, I suppose, of what you might call the key ingredients that you'll want to tick off. It all starts with that approach, really, and understanding what your employees want and would be happy with, but then obviously trying to square that and balance it with all of these different considerations you've got to make the business work effectively. And so, yeah, I've left that in as a bit of a at-a-glance page. What are the core things you'll want to cover off? One that I maybe didn't touch on there was engagement. So thinking about communication with employees, taking feedback on, is it working for them? You might do that through your formal appraisal system. You might roll out quick surveys or questions to see how they're finding it. Do they have any suggestions? That sort of thing. So that brings me to the end of home working and remote working. I'm just quickly going to touch on right to work checks because these changed on the 1st of October, but it may have gone under the radar with everything we've all had going on. Obviously, during the pandemic, it was well known that the traditional method you have to use to check someone's right to work was those rules were eased, and there was an ability for employers to use video calls, scans and photos of documents to make it far more informal so that those checks could still happen during lockdowns. So that has now gone, and from the 1st of October, there's going to be 3 methods really that an individual needs to go through to ensure that check has been carried out validly by the employer. So it's either going to be manual, it's going to be done online, or through an identity service provider. I've left this table here so at a glance you can kind of see, depending on what the status of the individual is, this is the method they're going to have to go down. In terms of the online method, that's going to have to be done through the Home Office's online checking system. In terms of the The remaining methods, you're going to have a choice really of a traditional manual check of their documents, or in certain situations for some businesses they might find that an identity service provider who you can outsource that check to, who can do it digitally for you. That may be a worthwhile cost for your business. That might be where you have high staff numbers, perhaps where you have a high turnover of staff in your industry. And obviously getting it wrong, I think it's easy to get it right. So if you put the systems in place, you shouldn't be worried. But the consequences are there. In serious cases, it could be a criminal matter. So I think it's about preparing for it. It's about thinking, getting your HR staff used to those systems again, because we moved out of that easy pandemic temporary systems. And there's a lot of Home Office guidance around it, what will and won't be accepted, and HR have been doing this for years, so it should be well understood, but the guidance can be quite clunky. So you might find that team members who joined during the pandemic who aren't really used to it, maybe they'd benefit from an easy to use guide. So it's just something to think about there. And that's my section done. I'm happy to take questions at the end, but I'll hand you over to Jack now.
Thanks, Patrick. Excuse me. Hi, my name's Jack. Sorry, I'm going to cough now. Sorry. My name's Jack. I'm going to take you through 4 topics today. The first one being national insurance and tax issues. We're going to go through a new bill called the Allocation of Tips Bill. I'm going to give you a brief history on IR35 and then go through a recent case on holiday pay called Harper Trust v Brazel. So, first of all, national insurance and income tax. As Joe said earlier, I'm sure we were all riveted by the goings-on in government, having 3 prime ministers in as many months. That has affected some things. It's slowed down some processes. But there's also been a lot of talk about things that might affect your employees, and that being national insurance and tax issues. So, in April, Rishi Sunak, who was then Chancellor, said that he was going to raise national insurance for employees by 1.25% in response to basically money spent during the pandemic. Sunak left. Boris Johnson left, and eventually Liz Truss and Kwasi Kwarteng come in as Prime Minister and Chancellor. And in his mini-budget, Kwasi Kwarteng said he was going to reverse this, and this from November 6th, the rise wouldn't come in. So effectively, instead of it going up to 13.25%, national insurance would stay at 12%. And then Jeremy Hunt comes in as Chancellor and confirms that that's the case. Quick show of hands, who knows how national insurance works? There was a couple there. So the way national insurance works is that most employees, there are categories that don't fit this, but most employees will pay nothing on the first £242 they earn per week. They will then pay the 12%, or what would have been 13.25%, on anything between £242 and £967. And then they pay 2% on anything above that per week. So it's just quite interesting because you all pay it, or most of you will pay it, but not many of you, by the sounds of it, knew how it actually worked. What does this mean for your employees? Well, courtesy of the BBC, we have this table, and as with any flat rate tax, the more you earn, the more you are going to save from the reversal of the national insurance change. So you'll see, broadly speaking, how much you would save depending on which pay bracket you are in. Now, I should say here that Jeremy Hunt is going to be doing a budget next week, and given Rishi Sunak was the architect of the rise in the first place, this might all change next week. A reminder of income tax thresholds. So everyone will get a personal allowance of up to £12,500. which you'll pay no tax on. Then you have a basic rate, a higher rate, and an additional rate. Just a note on personal allowance. If you earn over £100,000, your personal allowance reduces by £1 for every £2 you make. So anyone earning £125,000 wouldn't actually have a personal allowance anymore and would have paid it back. Back to Kwasi Kwarteng. In September, in his growth plan, Kwasi Kwarteng said that the basic rate would be reduced from 20% to 19%, and the additional rate of 45% would be scrapped. So, just going back to that table, your 45% is for anyone earning over £150,000. That obviously caused a bit of commotion and was scrapped quite quickly, and Kwasi Kwarteng labelled it a distraction. In October, Jeremy Hunt comes in and confirms that it's going to be scrapped, but also scraps the changes in the basic rate. So everyone's taxes were going to go down from April next year and are now not, in a nutshell. Another interesting thing though, this was supposed to come in all the way along, this was supposed to come in 2024. Kwasi Kwarteng brought it forwards and then Jeremy Hunt scrapped it entirely. So again, next week's budget, who knows? One thing I did read yesterday, though, is the additional rate. So that £150,000 rate might get lowered. Not the rate itself, but the cap. So instead of being 150,000, it might be 130, 120. We'll see next week in the full budget. But if you take anything away from this, your taxes are going to stay the same as they were, really. Moving on to the allocation of tips. Jo mentioned earlier that the employment bill, she's going to talk a bit later about the employment bill and where that's at. This allocation of tips was in the employment bill originally, but because the government haven't found time to actually pass the employment bill, what's happening is MPs are suggesting private members' bills now, and this is one of them. This will affect any business that works in hospitality, where employees typically get tips, so restaurants and cafes, for example. What the allocation of tips bill says is that employers will now be banned from withholding tips for their staff. So all tips should go to staff, less deductions. So it should run now through payroll. Your employees should get paid no later than the following month, and the worker has the right to request information on how tips are dealt with, because it's not quite as straightforward as giving all tips to the waiter that served you, because there are other staff, kitchen staff, chefs, who would also get a share of that tip. And that's why there will be a requirement to distribute tips in a transparent way, which means you're going to have a policy on it if this is something that affects your business. The bill also requires a statutory code of practice to be published, which hasn't yet been published, but when it does, I'm sure we'll talk about it in a future seminar or in a blog, so keep an eye on that. And finally, the right to get a tip will be enforced through the Employment Tribunal, and it's going to be difficult to see how that's going to work in practice, because presumably that would be an unlawful deductions of wages claim. The issue with tips are they're generally quite small amounts, so it might actually be disproportionate for an employee to go all the way through an employment tribunal to claim their tips back. So again, it'll be interesting to see how that works in practice. Moving on to IR35. Again, another show of hands. Who knows what IR35 is? 1 or 2, 3 I think we got there. IR35, this is an interesting little tidbit. IR35 stands for the Inland Revenue Press Briefing number 35. It was a briefing from the government in 1999. I've put the web address for anyone to go and look at that, which might well interest you because the press briefing is probably shorter than the amount of words I'm going to say on IR35 today. 20 years later, IR35 has morphed into this beast, which it can be quite difficult to get your head around, but I'm going to try in a few slides now. In a nutshell, IR35 was designed to stop individuals working as self-employed consultants through intermediary companies or limited companies. So to give you an example, HMRC used to hire a lot of IT staff. Those IT staff found that they could set up their limited companies, work as consultants, and then have their limited company be paid and then declare dividends, which has a lower tax rate. Similarly, in the NHS, a lot of doctors would work their usual shifts as employees and then work extra shifts on weekends as locum doctors, and would do that through a limited company, and the company would get paid and then declare dividends. So what was happening is HMRC weren't getting their tax. Under the original rules, it was the limited company or the intermediary who was responsible for assessing tax status and employment status and then deducting that tax. In 2017, the rules changed for public sector bodies, and in 2021, it changed for large and medium-sized private companies. What this did was it moved the tax assessment and employment status assessment from the intermediary, from the limited company, to the end user. So using my examples earlier, to HMRC or to the NHS, for example. In this case, a large and medium-sized private company is a company that has an annual turnover of more than 10.2 million, has a balance sheet of more than 5.1 million, and employs more than 50 employees. And it's if 2 of 3 of those things are the case, you will class as a medium or large company, and the burden will shift. That then became known as the off-payroll rules, because the IR35 rules are still in place for small companies where the contractor would do the assessment. In 2022, September, the growth plan reversed this and said, no, it's going to go back to the contractor for everyone, because this will unburden the end user, so the large or medium company or the NHS, as is the case. And that was to be effective from April next year. Now, ironically, this was really popular. With our clients who are corporate bodies, this was quite a popular change because the IR35 was, as I said, it was quite difficult for businesses to get their head around. And then in October, that reversal was reversed, and IR35 off-payroll rules are how they've been since 2017 or 2021. That's, again, at least for now. I'm now going to talk to you about a case called Harper v. Brazel, which is probably the biggest case that's come out in recent months, and it's to do with holiday pay. A bit of legal background for you to start with. Under Regulation 13 and 13A of the Working Time Regulations, all workers and employees are entitled to 5.6 weeks holiday, paid holiday each year. What the Working Time Regulations don't say is that you can pro-rata this for employees who only work part of the year. So this case concerns employees who are called part-year workers. The most typical of part-year workers are people who only work school terms, for example. But it can also be seasonal workers, people who come in for a few months of the year and then go. But everything I'm about to say is for people who work under permanent employment contracts. So they come back every year, they work every year, they're not fixed term workers. Historically, something called the percentage method was used to work out holiday pay for these employees. And holiday pay was calculated as 12.07% of hours worked. That 12.7%, a bit of maths for you all, that's worked out as there are 52 weeks in the year, 5.6 weeks holiday. 52 minus 5.6 is 46.4 weeks. So that's how many working weeks there are in the year that you can accrue holiday in. And then 12.07% is of 46.4 is 5.6 weeks. So that's how that calculation's always come about. It's never quite worked. It used to be guidance in ACAS, but for quite a few employees it doesn't actually work. One of those was Mrs. Brazel. So, Mrs. Brazel was a music teacher. She was employed by the Harper Trust. She was on a permanent contract, but it was a 0 hours contract. She worked term times only, and her work was typically between 32 and 35 weeks each year. Her hours depended on the amount of music lessons pupils at the Harper Trust required. At the end of each term, the trust would calculate all of their hours, divide it by 12.07%, and pay her that as rolled up holiday pay. She brought a claim that she was being paid too little holiday pay because the trust were only calculating her holiday pay for 32 to 35 weeks per year rather than for 52 weeks per year. And this worked out as her getting around 20 days or 4 weeks paid holiday. Now, as you'll remember, the working time regulations say all employees need to get 5.6 weeks holiday. She took her case to the Employment Tribunal, and the Employment Tribunal said, no, it's absolutely fine for you to pro-rata holiday based on the weeks that she works. She appealed all the way up to the Supreme Court, and the Supreme Court said she's entitled to 5.6 weeks. It's regardless of the amount of work she does in that year, but she's entitled to 5.6 weeks holiday. So, the court said that her holiday should have been calculated as an average over 52 weeks worked, not the 35 weeks worked, so going back into previous years, and not to include the school holidays. This artificially gave Mrs. Brazel more holiday based on the amount of hours, holiday pay based on the amount of hours she worked than it would for a full-time employee. But because the working time regulations don't allow pro-ratering, the Supreme Court said that that was what was intended, and that there might be cases where part-year workers end up with more holiday pay, and that's just how it's going to be. Because otherwise you are punishing staff for being part-year workers. In this case, instead of 12.07% holiday pay, Mrs. Brazel ended up with 17% holiday pay. So she got a lot more holiday pay than she got the holiday pay she would have got if she worked 52 weeks a year, even though she only worked 35 weeks a year. The good news is that this doesn't affect a huge amount of businesses. So it doesn't affect part-time workers. So it doesn't affect your staff who work 3 days per week all year round. It's only your part-year workers. It could affect staff who work on 0 hours contracts and come in for a bit of the year at busy periods. You know, we've got Black Friday coming up and we've got Christmas coming up, and your Christmas postal workers might well get caught by this, and they would be owed 5.6 weeks of holiday, even if they only work over the Christmas period. There are ways to mitigate this. For example, for your postal sorting office worker at Christmas, you could just engage them on a fixed term contract, because as I said earlier, this is only for people who are on permanent contracts that come back every year under the same contract. It also doesn't affect teachers, which you might think it would, but teacher staff is annualised over 12 months. so they get paid during the school holidays, and it wouldn't affect them. And that's my bit. So I'm going to pass back over to Jo, who's going to give you a bit more on the employment bill update.
Thank you. Yes, we're on the home straight on the final slot and the mystery of what happened to the employment bill. The government proposed the employment bill at the end of 2019 on the back of the Good Work Plan, with a view to improving the employment rights of the most vulnerable sections within the workforce. Because of the pandemic, the idea of the employment bill basically got kicked into the long grass, and the government said that they would legislate when there was parliamentary time to allow for that. I think we all expected that by May 2022 we might see some progress, but there was no mention at all of the employment bill in the Queen's speech in May 2022. So that's starting to cause some concern then that we're not going to see any reform. What the government then has done though to progress reform is it is supporting a number of private members' bills through Parliament which are achieving the same kind of changes as envisaged by the employment bill. And only last week in parliamentary debate the government confirmed that it is providing active support to 4 private members' bills. One of them is the Allocation of Tips bill, which Jack mentioned, and I'm just going to touch on the other 3 that the government are supporting, so that you're aware that these are things that are progressing through Parliament with government support. So the first one to mention is the Carers Leave Bill. There are about 2 million unpaid carers in the UK. And the proposal is to introduce a right for employees to take a week's leave during the year to provide that care for their dependents. So it'd be a day one right. So as soon as they've started, employees have the right to be able to take a week off. The right is to arrange or provide care for a dependent. And the definition of dependent is really very wide in the bill. It includes children, spouses, family members, household members, but also anybody who reasonably depends on you for care. So it's a very wide definition. The right is to care for somebody with a long-term care need. And again, there's a very wide definition. So it does include the definition of somebody who might be disabled under the Equality Act, but it also includes anybody who's got a long-term condition of 3 months or more. And it also includes anybody who might depend on you for care because of their age. So it's a very wide right that's being afforded. It's just to 1 week per year, and it's an unpaid week. And we know from previous experience that where leave is unpaid, employees sometimes don't choose to take it. But the leave can be taken in a flexible way to reflect the care need. So it might be that that's taking occasional days rather than the block of a week. We'll see the detail as it comes through in regulation. The Act will protect those who choose to take carers leave from detriment from their employer or from dismissal because they've taken cared leave. This is progressing through Parliament at quite a fast rate. There was the second reading at the end of October, and only yesterday there was a committee stage, and at each stage it's being successful and supported by the government. So it might move quite quickly, this one, and it's one to keep an eye on. And it wouldn't be too difficult a regulation to put in place because it doesn't involve regulating any pay aspects. It's just a right to leave. So that's certainly one to keep an eye on in coming months. More complicated is the neonatal leave and pay bill. So this would apply in cases where babies are admitted into hospital within 28 days of being born for a continuous period of 7 days or more. So you have a baby who is seriously challenged in the early stages of life. There's a recognition that that would be a very difficult time for parents, mothers and fathers. And in those circumstances, the proposal is that there will be an additional period of paid family leave to deal with that situation. So it's an addition to normal maternity leave, or shared parental leave. So it will be, we expect it to be continuous with those rights. Again, the leave entitlement will be a day one right. So if it happens in the early stages of employment, you're entitled to the leave. The statutory neonatal care pay, the entitlement to that will kick in after 26 weeks of employment, and that mirrors the rights to maternity pay and other family leave pay. Again, there'll be a statutory protection for employees who take this leave. They'll be protected from detriment and protected from dismissal. Because of the pay aspects of this and the fact that HMRC will need to put in place systems to reimburse pay because it's a family leave pay, we're told that that can take up to 18 months or so for those systems to be put in place. So we might see the legislation come in, but it's not likely to be effective during the course of the next year, I don't think. So again, it's one to watch, but perhaps not something to plan for immediately. But it is moving through Parliament with government support. We might, of course, have change of government before it becomes law, but that's one to wait and see. It has the support in consultation phases of employers and trade unions and all sorts of different organisations, including the government. So it's likely, I think, to become law at some point, but not imminently. And finally, just for completeness, the other private members' bill that the government is supporting is protection from redundancy for those in family leave circumstances. So at the moment, if an individual is made redundant or identified as redundant during the maternity leave period, that parent has a priority right to be offered any suitable alternatives vacancies that are available within the workforce. So that's a positive right. And the criticism of that right has always been that it only applies during the period of the leave. And what tends to happen, and we see this in practice all the time, is that when the mother returns from maternity leave, the redundancy situation kicks in at that point and the special protection isn't afforded. So the change that will be introduced by this bill will that the period of protection for parents and that priority to be offered a vacancy in a redundancy situation will extend from the point when the pregnancy is notified to the employer, so during the pregnancy itself, and also for a period of 18 months after the birth. And so for a 6-month period after return from a full period of maternity leave, the individual would still be in a protected period, and that's a very significant improvement on the rights of those taking family leave. That's all I had to say. Those are the 4 bills that the government's currently supporting, so things to keep an eye on in the absence of the disappearance of the employment bill. It's 2 minutes to 10, so we've finished just in the time. I wonder if anybody has any questions for any of us on the topics that we've discussed. Okay. Obviously very thorough, and if any questions do arise, then please just let us know, send them on the group chat or give us a call. So to close then, thank you very much for joining us. For those who are in the office, thank you for attending, and please stay, talk to us, ask questions, eat some more breakfast. Thank you to everybody who joined online as well. If you'd like to talk to us about any of the issues we've raised, please do contact us, pick up the phone or email us. I'll put up our contact details. If you'd like to talk to us about the services we offer, then you can talk to any one of us about those as well. In particular, we're happy to talk to you about our retainer service, Myosin HR. That's a 12-month retainer service for a fixed fee where you can have access to our team of 7 lawyers, talk to us, and it also provides access to all our online resources. So if you'd like to talk to us about that, please do so. Failing that, thank you very much for coming. I'm going to turn the mic off. Thank you.